So, Delegate
All
Watts.
right. Now, what the bill's focus is that, as you will note, subsection 1, line 18 is about violent juvenile felonies. Then 26 says any other felony. And now on line 32, we are saying that for any felony, whether it's violent or not, the court may, at its discretion, depart from any mandatory minimum sentence required by law or suspend any portion of an otherwise applicable sentence. So it's giving the court that discretion, particularly as far as mandatory minimums. And forgive me, this is all about the power of a circuit court in sentencing a juvenile offender. The language then, starting on line 56, essentially repeats that concept in saying that the court has the shall, in addition to considering other factors prior to imposing a sentence, consider the juvenile's exposure to adverse childhood experiences, early childhood trauma, any child welfare agency, and the differences between juvenile and adult offenders. This is basically standard practice that the judges typically would do. And with that, I think that's all I have. I think there's a very small thing on line 40. You have to take out the paren A. But other than that.
Just so everybody is aware of what we are doing, this is substantially focused, this bill, both in language and in scope. But this is a big change that we are saying that mandatory minimums shall not be mandatory for juveniles. That is the essence of this bill. So, Delegate, okay, Delegate Collins. Rob.
So, what I want to make sure I understand is that the circuit courts have always been able to sentence them as juveniles or as adults, but we have never given them the authority until this bill to say if you are a convicted violent felon and you're in possession of a firearm, it's a 5-year mandatory minimum. Now we're saying, court, there's still a 5-year mandatory minimum. However, you do not need to utilize that 5-year mandatory minimum if it's a juvenile.
The discretion of the court.
That's the new law here. Because we've always given the authority to change things, but now we've just forgot, or now we're choosing for mandatory minimums.
Well, I mean, this is saying that at the discretion of the judge, that mandatory minimums do not need to apply to juveniles if the judge so chooses, which is a very big change. Any other questions before we sort of open this up to?
I had one question. Thank you
Delegate
for this
Scott.
good work, Mr. Chair, to the patron. So I guess what I'm understanding, this gives judges the flexibility to kind of create more of a blended sentence to treat them a juvenile and adult. It looks like, you know what I mean? They get the best of or the worst of both worlds, depending on how you look at it, the best or the worst. Is that what I'm saying?
That's a good
Delegate Bell.
Could staff just walk us through what the judge can do now and what he could do differently if this passed? Just literally what the bill will do.
Mr. Chairman, current law, and this comes from the case of Brown v. Commonwealth from 2010, the Virginia Supreme Court was asked to resolve a conflict between mandatory minimum sentences and sections 1 and 2 of this code section, which allowed for blended sentences or for a juvenile sentence on a felony charge of a juvenile tried as an adult. So current law is if a charge has a mandatory minimum sentence, the judge must impose that mandatory minimum sentence as a prison sentence and cannot depart from that. So I think the ones that I see this in the case that was noted in the Brown case is the usually the attendant use of a firearms with other felonies. So you're tried for a robbery and use of a firearm by a felony. In the Brown case, they said that the court must impose that 3-year mandatory minimum, and they cannot depart from that, and it overrules the other options or the court may have under sections 1 and 2. This new bill, as amended now, would say that the court can suspend a mandatory minimum sentence for a juvenile offender tried as an adult that they do not have to impose the full amount of a mandatory minimum sentence. It could, obviously, once you have that prison sentence with a juvenile, you're going to get out of being able to use any of really the juvenile dispositions if you have to impose a 3-year mandatory minimum sentence or a 5-year.
All right, so, Mr. Chair, it's the current law, I guess. What this does is actually simple, but I don't know that I understand all of the court's options under current law. So there is I'm trying to think.
If you're tried, the example would be if you're tried for
17-year-old does blank.
17-year-old tried as an adult for a robbery. The court can do a number of things under that because there's no mandatory minimum sentence. They can sentence them to a fully adult sentence. They can sentence them to a blended sentence of adult or juvenile time and then an adult sentence, or they could sentence them completely as a juvenile under 16-1278.8. That's current law, except for in a case where there's a mandatory minimum, they have to impose the adult prison sentence mandatory minimum. Okay. And so if the example was a robbery and a use of a firearm, they would have to impose the 3-year use of a firearm charge and have no discretion to get rid of that to say, I would otherwise treat this as a juvenile case and give you commitment as a serious offender, but I've got to give you 3 years because that's what the mandatory minimum is for this charge. This law would allow them to say, no, I'm going to suspend that and commit you as a serious offender.
I got it. Thank you.
Delegate Delaney, you had your speak light on at one point, and then it was off, and then it was on.
It's gone. It's on.
Oh, okay.
It's gone. Welcome to court.
This is actually going to be a relatively short night for us when we're all done. So, all right, there's been quite a bit of discussion and clarification up here. Does anyone want to speak in favor of this bill?
Mr. Chairman, members of the committee, James Dold again. On behalf of Human Rights for Kids, just want to thank Delegate Watts for bringing this bill. When we talk about criminal justice reform, I don't think it's appropriate to have that discussion without first talking about how the criminal justice system treats children. In this country for far too long, we've been talking about broad overarching criminal justice principles, but perhaps no one has been hurt more by harsh mandatory minimum sentences than children. And this really started back in the late 1980s and early 1990s when there was a juvenile crime wave that happened, and a group of criminologists theorized that there's a new group of super predator children who are coming of age who are more violent and less remorseful than ever before. These children were characterized as being godless, jobless, and fatherless, and states were urged to pass transfer laws making it easier to prosecute children as adults, which opened them up to more extreme penalties. Fast forward about 15 years, the U.S. Supreme Court begins to weigh in on harsh mandatory sentences, including sentences like the death penalty, life without parole, looking at how kids are fundamentally different from adult offenders. And that's what this bill is about looking at how kids are different from adult offenders and restoring the discretion and the ability of judges to create more age-appropriate and more fair sentences in line with how kids are different from adults. I will also just note that there have been other state Supreme Court cases that have taken up the issue of mandatory minimum sentences around the country. State Supreme Courts in Iowa and Washington State, as well as Massachusetts, have also looked at these issues. And similar legislation has also been introduced in Congress by Congressman Bruce Westerman, who's a Republican from Arkansas, as well as members of state legislatures all across the country. So this is a trend that is continuing across the country. It's a really great bill. We would encourage the subcommittee to vote favorably upon it, and it may be one of the most significant pieces of legislation in terms of criminal justice reform that comes out this session. Thank you.
I appreciate your testimony. I will just say we're doing quite a lot, and we've done quite a lot so far in just the last 5 hours. So we're doing what we promised. Yes.
Mr. Chairman, Derek Davis, Commonwealth Attorney for Surrey County, speaking on behalf of the Virginia Association of Commonwealth Attorneys, and we support this bill. These were actually amendments that we recommended.
I just want to no. I want to time out here for a second because
I'm your friendly, reform-minded prosecutor here today to talk to you.
And with a fantastic haircut, I must say. All right, let's hear this.
So this was actually amendments we suggested as a consensus of our association We support doing away with mandatory minimums for juveniles. However, we did not feel that it should be done in a piecemeal fashion, and that it be done based on who the victim was and incentivizing vigilantism. So, but as a principle, our association supported doing away with mandatory minimums for juveniles. We think anything that gives the judges more discretion in appropriately handling these cases is the best thing for us.
Mr. Chair?
Yes, Delegate Bell. I'm sorry, I'm looking at my Commonwealth
So like the
attorney for a
mandatory
second.
minimums that say that if you shoot and kill an officer in the line of duty, that we were able to get through last year with significant objection, you don't think that should apply to juveniles? I understand that there's Supreme Court issues as it goes down the road about a mandatory parole of some sort, but you don't think that should apply to juveniles?
The consensus among the association was that we felt as a principle the mandatory minimum shouldn't apply. Now, in a case that is egregious that way, the judge still has the authority and the discretion to sentence at that mandatory minimum or higher.
Well, by definition, you're saying that there should be circumstances where that penalty should not apply, right?
Not necessarily. We're
So
saying
every
the
time it
judge
should
have
apply,
the discretion.
but there just shouldn't be a requirement that it apply. But every time you want it to apply.
I'm sorry, could you?
No, skip it. That's all right. I withdraw the question.
Is there anyone who would like to speak against this bill? Seeing none, Delegate Watts and anybody else on the committee? All right, if there are no other requests to say anything, is there a motion or pleasure of the committee?
Move to report.
There is a motion and a second. All those who wish to report this bill. The bill reports 6-1. Clerk will close the roll.